Today, I'm going to talk to you about our top 10 most common landlord and tenant board issues that we see from the landlord's perspective within our firm on a daily basis. My name is Dan Schofield. I'm a partner and I'm a litigation paralegal with SFG Paralegal Services in Richmond Hill. Our phone number is 888-398-0121. I can be reached at dan@sfglegal.ca. You can also reach our firm at info@sfglegal.ca, and one of our litigators or our intake people would be happy to answer your questions for you and see if there's a need to employ our services. So the first thing I want to talk about is what are the top 10 most common issues we see. So that's non-payment of rent, persistent late payment of rent, damage or interference with either the landlord or a tenant's reasonable enjoyment or lawful right and privilege, subletting, mistakes on notices, illegal entries, eviction for owners, purchasers' own use, human rights accommodation, smoking, cultivating marijuana, and small claims court notices. So first, the question that we get asked a lot is, when should a non-payment of rent notice be served? Well, the answer to that is the day after rent is due. It doesn't matter what calendar day your rent is due. If rent is not paid on that day, the next day it would be considered late and you should serve a notice. Anecdotally, we tell our clients it doesn't matter whether you have one door or 700 doors, you should always serve a notice if rent isn't paid on time. And the reason for this is because by not doing so, you delay any remedies that you have in collecting that rent down the road. So for instance, if you file your notice 2 months down the road, you'll now be 2 months in arrears. The tenant will have a voiding period. It's typically 14 days, depending on how it's served. And then only after that 14 days can you now serve a new notice. So you could potentially be 3 months in arrears just at the time of filing the notice. And then there's going to be some delay in getting to the landlord and tenant board. And then certainly once the tenant has a hearing, there's no provision that would see that tenant evicted on the same day of the hearing. There are other issues that would go in that would further delay. So you could be out rent 8 or 9 months prior to getting to the board. And why would you delay that process 1 or 2 months? Now, sometimes tenants get offended. I would simply suggest that you explain to them that this is a business for you and that you understand they might be having a hard time and they can certainly pay any rent that they owe you in order to void the notice anytime up to the hearing, but that you have to serve the notice to protect yourself. The notice should be exact. It should include dollars, it should include cents. We once had a client a few years ago who told us that rent for the rental unit was $1,700 a month. They filled out a form that stated it was $1,700 a month. We prepared the notices for them. The client approved those notices, and then we got to the board, and the first thing out of the tenant's paralegal's mouth was that our notices were defective. And when the adjudicator asked how, he said, rent is not $1,700 a month. Rent is $1,699.53 a month. And that is absolutely enough to void the notice. So you have to make sure that you are exact. You shouldn't include NSF charges. You shouldn't include interest. You shouldn't include rent increases that were not done in accordance with the Residential Tenancies Act. So let me tell it to you this way. If you did not increase the rent on an N1 or an N2 notice, you did not increase your rent in accordance with the Residential Tenancies Act. And all the advice that I'm going to give you for that is you need to speak to a lawyer or paralegal prior to even starting your notice, because you could be opening up a Pandora's box of many issues that really should be taken into consideration in conjunction with a legal representative before you move forward. All the names that are included should be names of tenants, and you should not be putting occupants. Now, the obvious one that comes to mind when people talk about occupants is they'll say things like, well, we don't want to name kids on the application, but there's an even stronger legal implication when you name an occupant. And that is, if you name an occupant on the notice and the original tenant leaves, that occupant may turn around and say he was a tenant the whole time. And the reason he was a tenant and that he can prove that he was a tenant is because if he was just an occupant, why was his name listed on the notice, or why was her name listed on the notice? So it's really important that the only names that you put on the applications or in the notices are those of the tenants who's actually signed the lease agreement as a tenant. Now, there is some debate on this next point. I'll put it to you this way. There is a case called the Law Society of Upper Canada versus Shirelli. The purpose of this case was to determine that A property manager could not represent a client. Part of that representation included filing the necessary applications and going to the board. Not everybody agrees with this decision. There's various opinions versus whether representing the landlord starts at the time that the notice is signed, or whether at the time that the application is signed, or whether or not representation only includes the landlord and tenant board. There are some adjudicators who will dismiss based on various reasons. I'm not saying that they're wrong, but I'm going to say it's a controversial issue. So based on what my original comment was, we're saying that it could be potentially, 8 months before you see an eviction. I would suggest that the worst case scenario is you going to the board after being on wait for 4 or 5 months or 6 months, and then having to start all over again because the wrong person signed your notice. So I would suggest that that any notice that you issue should either be signed by yourself or signed by a paralegal or a lawyer licensed by the Law Society. It's up to you. I'm not telling you that one way is more correct than the other. I'm just telling you what the existing case law says. Now, what is persistently payment of rent? So when you look in the act, there's nothing that says that the 5 months payment is persistently late, or that 6 months payment is persistently late. What it does say is that you can seek an eviction after the lease term of the tenant is over if they have consistently paid their rent late. Now, we find that as a general rule, when tenants pay their rent late at least half of the length of the last year, that is something that an adjudicator would consider persistently late. But just because the adjudicator finds that the tenant has paid the rent persistently late doesn't mean they're necessarily going to terminate that tenancy. And I'll get into that later on down the slide. A landlord should, although not required, serve an N4 when the rent is considered late. The reason for this is because evidence is key when you go before a member. A member is not just going to take your word for it. What they're going to want to see is that you took steps to remedy that non-payment of rent or that late payment of rent, and that you have the evidence to supply that. Now, if you don't have it, it's not necessarily fatal, but you should definitely consider it. You should keep copies of those N4s, and you should also keep a rent ledger of when rent was paid. Now, rent ledgers, they don't have to be complicated. They can be done in Excel or even Word. All it is just a snapshot that you take every month of when the rent was due, how much the rent was, when it was paid, and what day it was paid. You'd be surprised how many people don't keep that kind of information, and they have to search for hours through their banking information to get it. Whereas if you just kept a record of it from the start, you would have it right away. Now, what will most likely happen? So the tenancy will most likely remain if there's not a substantial amount of arrears, or if the board finds that based on whatever circumstance the tenant did not pay persistently late, the tenant will most likely remain in the unit. What could occur and what may occur is that the landlord will receive what's called a pay on time order from the landlord and tenant board. And a pay on time order is based on Section 78 of the Residential Tenancies Act. And the Section 78 clause basically says that if rent is not paid on time and in full for a period of time, usually 12 months, that the landlord doesn't need to serve any further N4s, doesn't need to serve any N8s. They simply need to file the proper application with the landlord and tenant board, and that tenant will receive what's called an ex parte order in the mail. Now, just because you've filed it and you've received an order, there are obviously reviews and other steps that can be taken by either party that may cause that order to be reviewed or turned down in effect. But as you have to start the process at some point, and that is a great way to get it going. And again, it should include the names only of the tenants, not of the occupants. And that's really important, as I stated before. So reasonable enjoyment of other tenants interfering with the rights of the landlord. So first of all, what is damage? So we usually talk about the fact that damage is anything other than wear and tear to the rental unit. You should really call a lawyer or paralegal to verify what you're saying is damage is really damage. There are other charts that, just to give you an example, if you go to the Residential Tenancies Act, online, there are things called Ontario regulations, which the general public typically doesn't pay very much attention to. And if you go into the if you go into the Ontario regulations and you scroll down to certain ones, they have weighted tables of, how long is the useful item of something. So I am going to make sure that I'm sharing the proper screen when I go into this. Let me just stop sharing really quick. Share screen. So right here is one of the tables that I mentioned about. These are tables 4, 5, 6. They go on to talk about the useful life expectancy of doors and windows, finishes that you might put in, ceramic tile flooring, mirror panels have a 10-year life expectancy. They talk about exterior paint and trim, interior paint and trim having a 10-year life expectancy. Various other furnishings that are available. And again, these can be found under the statute for the Residential Tenancies Act. You would look under regulations under these acts, and the regulations in this case cover things like tenancy agreements, suite meters, maintenance standards, and then just generally information that might be available that you might want to know. And the reason that I point that out is because while you may not necessarily need that information, I have seen adjudicators consider it before. So if you have a tenant who's living in a house and they've scratched 20-year-old hardwood floors that have never been redone, meaning that the coating on them has now, become very thin and it's very easy to scratch those floors, the landlord and tenant board is not going to necessarily look at that as actual damage. They may consider that as wear and tear. So what's really important, and also you need to have some photo or proof that prior to the tenant moving in that damage didn't already exist. And you should do that when the unit is vacant, and you can take pictures of floors and walls and other issues in order to ensure that when you go to the board on a damage application, you have a well-evidenced claim of your damage. Reasonable enjoyment of other tenants. So a tenant or a tenant's guests, they can't interfere with other tenants. Interference could be things like smoke, loud noise, fights. It's your responsibility as a landlord to provide a termination when receiving complaints for other tenants. But those tenants also have to participate in the process. So we'll get landlords calling us up and saying they need to serve a notice to a tenant for interfering with others. But then when I say, great, are the people who complained about that tenant willing to come to court? Their response often is no. And that person has to come and testify. As a landlord, you cannot testify to issues that you were not personally aware of. You can testify that you received a text message about something. You can testify that you received an email about something, but you can't actually testify that something occurred. And so that's why a tenant must be willing to come and testify to the complaints, either on Zoom or in person, whichever happens to be the way that hearings are being had at that time. Again, just another story to emphasize this and the reason why it's so important. We had one tenant, a lower floor tenant, complaining about an upper level tenant, testifying to noise and other such things that they were complaining about. The tenant didn't want to come, so we told the tenant if they didn't come, we would have to withdraw our applications. She ended up coming to testify. And during the course of her testimony, it was discovered that in reality, she just didn't like the upstairs tenant. And a lot of times that she was sending emails or text messages to the landlord complaining about them, the upstairs tenant wasn't even home. So that is something certainly that adjudicators will look at. Interfering with the rights of the landlord. So if a tenant puts an above ground pool and all of a sudden the landlord is getting calls from bylaw because he wasn't allowed to do that or she wasn't allowed to do that, those are reasons that you can evict. You can refuse If the tenant refuses reasonable requests for entry, a landlord could provide a notice of termination for that. Because a tenant and a landlord are expected to cooperate with each other when maintenance needs to take place, or when the landlord just wants to do a general inspection of the unit. That's governed by Section 27 of the Act. There's also Guideline 19 on the Landlord Tenant Board website, where you can go and get more information about it. What is absolutely, though, necessary for these notices is there's a 2002 case called Ball and Metro Capital, and I would say that this is a leading case. It's used by the Landlord and Tenant Board as well as many legal representatives. And what that case says is that before you can put something into a notice, that notice must be specific. That notice must list a date, a time, and it must list a specific allegation. And the reason for that is so that a tenant has the right to bring evidence to dispute those allegations, should they believe that those allegations are false. So if you were to say, between September and December, the upstairs tenant complained of smoke and you're smoking in your unit, that is not specific enough. And it's not specific enough for the same reason that I mentioned prior. How do we know that those tenants just don't get along and that the upstairs tenant is waging a complaint? Maybe that person wasn't even home. So by saying on the notice, on September 3rd at 4:30, the tenant upstairs smelled smoke coming from your unit, that gives them the ability, A, to prove if they were even home September 2nd at 4:30 p.m., or if they had guests over who can testify to the fact that they weren't smoking. It gives the tenant the ability to defend the application, and therefore it gives your application more credibility if the tenant is unable to defend. So again, it needs to list all the tenants within the property. It should not include occupants. Subletting and early termination. Now, look, I'm going to be completely honest with you. I do not see any advantage to yearly leases in the province of Ontario. They protect the tenant, which is great. And if you have a tenant who's a good tenant and deserving of that protection, then you should certainly give that to them in exchange for them paying rent on time and taking care of your unit. But entering into a brand new tenancy, I would argue there's no real advantage to it. Under Section 95(4) of the Act, a tenant can give a notice of termination. Under Section 96, within 30 days, if the tenant wants to assign or sublet the unit and the landlord refuses or doesn't respond, or the landlord rejects a potential assignee. There's so many reasons why, so many abilities for a tenant to break their lease that I just simply don't see the advantage to a yearly lease anymore. On a month-to-month lease, if you decide you want to sell the unit, you can. If you decide you want to move into the unit, you can. If you decide that if the tenant is persistently paying rent, you can address that with the board earlier. And certainly the tenant can leave whenever they want just by providing the proper 60-day notice, as dealt with at the board. The tenant can be charged a penalty if they want to leave early on a lease, but that penalty has to be reasonable. So maybe additional real estate clauses or real estate agent fees, or maybe some cleaning fees, but you're certainly not going to recoup. If the tenant leaves 6 months into the lease, you're not going to recoup 6 months worth of rent. So I would argue, like I said, there's no advantage. Mistakes on notices and agents' duties. So notices must be error-free. Now, let me explain that, because a lot of people don't understand the difference between a judge and an adjudicator. So a judge is able to take something called judicial notice. They can say, I acknowledge the fact that the address that you put on this notice was wrong. And as a result of the address being wrong, I am going to take notice of the fact that you're talking about Unit 2 within that address. But adjudicators don't have that same flexibility. And in fact, they don't have that flexibility because the Act says very specifically that the landlord must specify the unit number in any notices they serve. So dates must be at least 60 days notice. The Act is very specific about what are the requirements that are placed on notices. So notices have to be error-free. Like I said, if there's a mistake on a unit number, or the notice isn't served properly, or the entire notice can become void. So if you mail it, but you don't add 5 days for mail, that can void your notice. Uh, in some cases, this means that a landlord can go months without receiving rent. Also, when you have an agent working for you, whether it be a real estate agent or a property management company, um, they have a duty to make sure that the notices are error-free. Certainly, a lot of companies have property management. If they don't, that they could be negligent, and you could possibly deal with that through the courts against your property management company. And I would also say that any agreement you have with a real estate agent or a property manager should almost always be in writing. And the reason I bring that up on this presentation is because we'll see landlords come to us and say, I haven't received rent from my brand new tenant since they moved in. And I'll say, great, well, who found you the tenant? Oh, my realtor found them for me. And did the realtor do any of the screening of the tenant? And they'll say, well, no. And when I contacted the realtor and I complained, they told me that in their contract with me, it was actually my responsibility to screen and the tenant. So the realtor brought them all the information in order to screen. The landlord didn't do it, whether that was because they misunderstood the agreement and thought that the real estate agent was going to screen, or whether they just were simply lazy in defining who was doing what. It could be an issue. So while notices should always be error-free, you also always want to make sure that you have a properly defined contract, because if one of those parties breaches a properly defined contract, you may have civil remedy to go after that person for damages or any rental arrears that you may have. Consider what correspondence was exchanged, which may limit the agent's retainer. So if the agent says, look, I just don't feel comfortable with this person, even though they have all of this, and you choose to do it anyway, that could be an issue. So this would really be something that's case specific, and you'd probably really want to talk to a lawyer or a paralegal, specifically a lawyer or paralegal who deals with residential tenancy and understands the interplay, and small claims court and understands that interplay. And this was all talked about and said in Meadow Ridge Classic Realty in 2014. That was done in BC. Again, I have the general warning about who signs notices. I'm not going to go into that again, but you should probably look at it. So what is an illegal entry, or what happens if a tenant is denying entry? So all notice of entry, unless an emergency, I apologize for the spelling mistake there, I just noticed it. All notices of entry, unless it's an emergency, must be in writing. Email and text messages are fine as long as they've agreed to in the standard lease that landlords put forth with their tenants, and that the tenant responds is always helpful. And they must be given at least 24 hours prior to the entry, and they must be as specific as possible. So you can't just say to a tenant, I'm coming in between 8 a.m. and 8 p.m. The entry should be limited to a time period, maybe between 2 and 4 or 2 and 5. When booking a showing for an agent, they should always try and leave some room on either side, so they're not early and they're not late. So you don't want to be in a situation where you gave a notice of entry for 2:30 and you're going in at 2, and you don't want to be in a situation where you gave a notice of entry ending at 3 and you're there at 3:10, because then you're in breach of the entry if you were really specific. So you always want to make sure you give a good enough window to get done what you want done, and not so tight a window that you could be in breach just because of a traffic accident, or you hit too many red lights. Landlord and agent should always knock and announce themselves. I can't tell you how many times we see complaints where somebody says, well, I was just hopping out of the shower and I went to my room with no clothes on, and my landlord was standing there looking at the closet. You should always knock and you should always announce yourself. There's no requirement for a tenant to be home. It's their choice. You cannot ask them to leave. That is not your choice. But it's not required for the tenant to be home when you do the entry. If a tenant refuses entry, that is a grounds for an eviction under most circumstances. And just to give you an example, I mean, I'm not going to say that every single time an illegal entry occurs, that this is the amount of money that's awarded. But the most amount of money that I've ever seen awarded on an illegal entry was at Rona and Toronto Community Housing, where Rona was awarded $1,000 per illegal entry into his unit, even though he had consented for the landlord to come in. So the landlord had knocked on his door and said, "Hey, do you mind while we're here if we just take a quick look at A?" And he allowed them in, and it was still deemed an illegal entry because he didn't receive the proper notice. Eviction for own purchaser's own use. So a notice must be served in accordance with the Act. The notice must be at least 60 days notice, and it must end on the last day of the rental period. So you can't serve a notice, let's say, January 1st and have it end on April 2nd, because that's what you calculated to be the amount of days. It would have to be the end of the rental period. That's very important. Now, there are some rules within the Act to deal with that, and I'm not going to get into every single. I know that some people are probably watching and they're saying, well, what about this law? And what about this rule? I'm just talking in really general terms. And that was the easiest way for me to illustrate it for you. If you're serving notices, obviously, I recommend that you seek some legal advice and make sure that the information based on your specific circumstance is accurate. The owner purchaser intends to move in. Your tenants have to be compensated 1 month's rent, and that needs to be paid before the termination date of any notice that you served. And that person will have to sign either an affidavit or a declaration. I prefer affidavits. Some people prefer declarations. That the person intends to move in and stay there for a period of 12 months if they are the owner. Purchasers do not yet have a 12-month requirement. I mean, that's something I'm sure will come. They don't have it yet, but they do have to take lawful possession of the unit. And because they are swearing, they can't evict a tenant that's already in the unit just because they feel that the tenant's not paying enough rent or the tenant's been there for so long. That person has security of tenure, and really what you're doing is you're saying, I'm going to move into this unit, and you're going to write an affidavit or a declaration to that point. And if you don't move in, then there could be some legal repercussions for you in that regard. If you are a owner, the unit cannot be sold or re-rented within 1 year of the person moving in. And if it is found that the person that you said is moving in on the notice didn't move in, the penalty, and I'm not saying it's automatic, but you will most likely get a penalty of assessed of the difference in a tenant's new rent for a period of 12 months. So if you had a tenant paying $1,000 and now they're paying $2,000, it'd be $1,000 times 12. An award of 12 months of the total rent that the tenant paid prior to leaving. So again, if it was $1,000 a month, then you could face another $12,000 in damages, now at $24,000. Reasonable moving expenses is determined by the board, a possible board fine, and the monetary jurisdiction of the court is $35K. Now, I say a possible board fine because while you can technically be fined, I don't see it happen very often. It doesn't mean that it wouldn't happen. And I think it would be more case specific in regards to the behavior of the parties that would determine whether a board fine would apply. Human rights accommodations. So you have a tenant, they're refusing showings. They stated that they keep Saturday or Sunday as religious family holidays. Also, they're refusing showings after 7:30. That's the bedtime of their child. Are they being reasonable? Well, the Ontario Human Rights Code says you as a landlord must accommodate those tenants to the point of undue hardship. Undue hardship is one of those legal terms that's really not defined anywhere because it is very specific to each situation. But I would suggest that if a tenant is saying, I'm, an Orthodox of whatever religion, and, my Saturdays are reserved, or my Sundays are reserved for religious observation, that trying to go in on those days would be contrary to the Human Rights Code. I would argue that if they have children who are either asleep at a certain time, it would be contradictory to the Ontario Human Rights Code for you to force an entry after that occurs. as long as it is reasonable. So, keep records, keep notes, work with the tenant. The tenant has a duty to aid in their accommodation. So if they're saying that they don't want you to enter at certain times, then they also would have an obligation to tell you, especially if asked, when it would be okay. They can't just blanketly refuse. Even with COVID and all the issues that are going on with COVID, a tenant cannot just simply refuse entry, and notices can and should be served in some of those circumstances. I see in cases where a landlord doesn't want smoking within the unit, and there's, realtors use something called web forms where there's, certain clauses that realtors will use to prohibit smoking in the rental unit. Where they'll define smoke or smoking. These are fine generally, but something that you should be aware of is that you can't prevent things like Aboriginal smudging. You can't prevent somebody from burning incense if that is part of their religious practice. They're smoking a hookah pipe or something else that's part of the religious practice. You can't actually stop that. If somebody is smoking cannabis as a result of a human rights accommodation, you may possibly be able to work it out. Well, you have an obligation to work out an accommodation plan with them that sees them being able to medicate while not necessarily interfering with other tenants. So leases can include a non-smoking clause. They can include a non-cultivation clause. So even though somebody may be legally entitled to cultivate something within their own property, you can stop them from cultivating it with a lease clause, and it is enforceable. Again, if a tenant comes to you and says, well, I smoke marijuana because of anxiety or some other disorder, and the marijuana helps, I have cancer and it helps with my pain, you might want to consult with somebody before you just simply say to them, I don't care, you can't smoke it here. That would be really important. Now, with Bill 184 coming out, there's some more clarity on what I'm about to talk about. So the conundrum before was always, where do I bring my claim? Do I take it to the LTB or do I take it to small claims? And then the tenant would leave, and then you couldn't take it to the landlord and tenant board anymore. You had to take it to small claims. And then there was case law evolving in small claims that says that they didn't have jurisdiction, and based on discoverability or other issues, it should have gone to the board. So now we have this process has been really simplified by the Ontario government with the introduction of Bill 184. So basically, if the tenancy ended after September 1st, 2021, you have the right to bring that tenant to the landlord and tenant board for up to a year after the tenant leaves. Prior to September 1st, 2021, the landlord and tenant board does not have jurisdiction to hear it, and therefore you may find that small claims court is more consistently available to those people in order to claim those damages. So that's the end of our top 10 list. Oh, yeah, so this is basically all we spoke about before. So that's the end of our top 10 list. Again, my name is Dan Schofield. I am a licensed paralegal based in Richmond Hill, Ontario. If you have any questions regarding the presentation that I just did, please feel free to reach out to our firm. My contact information is also in the description of this video, and have a wonderful day.